Now a Finnish court has sentenced Simon Ekpa, a pro-Biafra activist living in Finland, to 6 years in prison. He was found guilty of terrorism-related offenses, tax fraud, and practicing law without authorization. Judges said Ekpa used his network to incite violence, supply arms, and push for a Biafra revival. Back in Nigeria, Nnamdi Kanu's terrorism trial remains stalled. After years of legal disputes, a new judge took over earlier this year. Now, hearings resumed in March with the first prosecution witness testifying in April, but progress has been slow. Courts in both Kenya and Nigeria have already ruled Kanu's 2021 rendition from Nairobi unlawful, raising questions over the legitimacy of the trial. Critics say dragging it out only fuels tension and undermines confidence in Nigeria's justice system. Observers point to Finland's case against Ekpa as an example of due process done right, and warn that Nigeria risks international damage unless it handles Kanu's trial with transparency, speed, and respect for the rule of law. Now, for a conversation about the impact of Simon Ekpa's arrest and conviction and the lessons for Nigeria's judicial process in the administration of justice is lawyer Malachy Ugwummadu. I want to say thank you very much for joining us today.
Thank you for the opportunity again.
All right, so let's get straight into it. Before we talk about the snowball effect of this Simon Ekpa's issue and the judgment against him, and how it relates to that of Nnamdi Kanu. First of all, what do you make about what the Finnish courts ruled against Simon Ekpa?
Well, I think justice was served in the sense that Simon Ekpa was subjected to the crucibles of trial, criminal justice trial in Finland. And by the way, Finland is reputed to be one of the most credible judicial systems in the world, in terms of integrity, in terms of impartiality, and in terms of justice delivery system generally, talking about speed. So if it was lucky to have had this matter handled there, the assumption is
You presume that to be luck?
Well, when I said lucky, it could have been tried in Russia, it could have been tried in Iran, or no less in Nigeria.
Okay.
So the fact that a country adjudged to have the best justice delivery system had him on trial, sentenced him, convicted him, and then sentenced him subsequently. For me, that's also lucky. It's lucky. Some are just extrajudicially executed. So, having said that, I think that is the point to make there, that he found himself subjected to a judicial system that is adjudged to be credible, to be dependable, and to have some measure of speed, considering that justice delayed, as we normally say in the legal circle, is justice denied.
Yeah, so if we were to pick up from that, your last statement, justice delayed is usually justice denied. That particular phrase or statement doesn't apply to the Nigeria scenario or the Nigeria judicial context.
Well, it is convenient on your part to put it that way. But for those of us who are practitioners, we take it in context. Quite a number of factors are involved. There are a couple of variables, some within and some outside your control. And when I say your control, I mean the control of the judiciary as an institution, an arm of government in most jurisdictions. Here is what I mean. In recent years, and this is rather painful, I've been in courts, appellate courts, courts of coordinate jurisdiction, National Industrial Court. In fact, this is not my words. I think the last Chief Justice of Nigeria, the penultimate Chief Justice of Nigeria, before he assumed office, he led what looked like a subtle protest in the entire judicial system in Nigeria and complained that one of the problems they have is that it has gotten so bad up to the point where power is rationed in the courts. We as practitioners witness that, where you are expected to do all you needed to do because by 2 p.m., 3 p.m. thereabout, there's going to be power outage, particularly when they are subjected to use generating sets. And most often, it is always the case. Now that goes to the issue of funding and infrastructure to deal with the justice delivery system. So you're not just talking about the knowledge of the law, the expertise required, the courage, and the independence needed to dispense justice as it ought to. You're also tackling with institutional crisis, government issues, infrastructural issues.
But the
now,
question
the reason I put it that way, the reason I chose to take you on is to say that the framework of the law in Nigeria today is designed to ensure speedy dispensation of justice. I give you an example.
I doubt that strongly, because how would you know? Because when you want to explain it, if we take a land case, for example, because I look at some of these land cases, and you will be shocked how they decide to extend the process. And at the same time, when you see some election cases, and you see expedited hearing, and you begin to ask and question and say that it should be that what is good for the goose is good for the gander. When they want to have expedited hearing, especially when it requires political issues to be solved here and now, like we see in Rivers State, for example, or probably if the presidency is in dispute, we see expedited hearing as against the regular case. And that still goes back to the point that justice delayed is justice denied. And in Nigeria, we have seen grave injustice, miscarriage of justice, not thanks to the fact that extended cases go on for life sometimes.
Aaron, the concern you have expressed is not limited to you. In fact, the average Nigerian presently holds that view. I was interviewed by your station in Enugu just a few days ago, less than 3-4 days ago, where we had our annual general conference at the International Conference Center at Enugu. I had cause to respond to this, but now not in details. So here is the point. I have always said, again on this year's station, that the notion of justice itself takes a flight. It evaporates. Not at the point when you win or lose a case, even if it was just within 1 month or 4 years or 5 years, as the case may be. The notion of justice as a very crucial topic in our study of jurisprudence.
Yes.
It disappears when the ordinary man on the street, not Aaron, not Malachy, who are professionals, lose confidence. And that is the point you are making.
Yes,
we are particular about it. We are very close, if not at that point, where the average Nigerian has lost confidence. And this is a big worry and a big concern to the legal profession. And it keeps occurring year in, year out within our bar conferences and all that. But I was making the point that whereas we have these institutional, logistics, infrastructural challenges, the legal framework itself to guarantee speedy dispensation of justice are there. I quote just one example, just to tell you that there are practical steps taken in that direction. Section 396 of the Administration of Criminal Justice Act, specifically subsection 3 and 4, insists that there should be day-to-day trial in every criminal matter. Criminal matters should be tried day-to-day. Where that is impracticable, that's the language of the Act, under subsection 4 of 396 of Haja 2015, where day-to-day trial is impracticable, it shall not be extended. In other words, adjourned more than 14 days. And by subsection 5 of that section, it says, you as the defendant who has been brought to court to defend a charge or an information against you cannot seek adjournment for more than 5 times throughout the duration of. All of these are mechanisms designed
to expedite.
But when you now have such situations, because we practice, and suddenly there's an outage of power, for instance.
Yes.
What do you expect the judge to do? What do you expect the lawyers to do? Courtrooms are usually very congested and compacted. The heat becomes... Some judges, in fairness to them, and this is where we need to be a bit charitable to them, continue. I have seen judges who put on their own electrical lamp,
Okay.
to illuminate the process, knowing that the light may soon come and all that and all that. So these are not the entire picture. So the law and the legislations are designed, they are in conflict with the infrastructural institutional challenges.
Okay, so permit us to now bring it, try to dial it back home to our initial discussion about Nnamdi Kanu, the way he's been treated, the way they've gone about the case, the impunity in which some people feel, or some people feel that the impunity in which the legal system has actually visted into his case has been grossly unfair, and that probably onlookers from the international community will see Nigeria's judicial system as not a joke, but as a judicial system that do not understand the ethos of justice and also the respect for the rule of law. Because truly, in the handling of his case, the rule of law has taken a backseat, has been thrown out of the window, and it's more about personal predilectives as against taking him to, giving him his day in court and trying to try him and prosecute him for said crimes.
That can both be conclusive and judgmental. And I say this because if you get to the heart of what is playing out right in the courtroom, you could see quite a number of intrigues, some orchestrated even by the defense counsel in a way that prolongs the matter. Change of counsel, for instance,
yes,
is a fundamental right.
Yes,
under
it is.
Section 36 of the Constitution of the Federal Republic that says, in the determination of the right and privileges of every Nigerian, such a person shall be entitled to fair hearing within a specific period of time and then before an impartial tribunal. And such a defendant shall be entitled to a counsel, or a lawyer, or a legal team of his choice. So if you want to change your counsel, that draws directly from your constitutional rights. However, it has implications. Before you can move into a criminal matter, if you are properly groomed as a defense counsel, you can't be second-guessing. You must, of necessity, have a full background and the details of what has transpired. That cannot be by hearsay.
True.
It can only happen if you apply, for instance, for the entire records of proceeding, sometimes certified true copies of those. All of these take time. I'm not going to say that that is exactly what has happened or that is what has delayed this matter, but I make the point that whereas the prosecution may be doing what it's doing, the defense counsel, on their own part, trying to seek justice, which they are entitled to, may also have been playing into the hands of a delayed procedure. So the concern I have personally is that there have been rulings in the Nnamdi Kanu's case that has not been obeyed. And these rulings that remains disobeyed sends a very bad signal, not just to the Nigerian judicial community, but the international community, where this case that has some international dimension, don't forget he was extradited, people have called that rendition, and then the same person with whom he was running this whole show has just been convicted. All of these play in the perception, in the apprehension, if you like, of the international world with respect to our own brand of justice delivery system. And I think that should be a concern without necessarily going into the details of what is happening.
Do you think, in all fairness, as I wrap up, that there will come a day where Nnamdi Kanu, in the next probably 6 months, will either get convicted or acquitted?
There is what we call fast tracking of a case.
But clearly, this APC government are not interested in that, because I say the APC government because this started from the Buhari administration and it has spiraled into the Tinubu administration. So I say the APC government are not interested in that. Do you think that day will come where he will know his fate in life?
As a Nigerian and as one who is keenly interested in what is going on, including criminal trials, in short, I also do a lot of criminal defense. I would tell you that successive governments that has some inclinations towards politically exposed individuals who find themselves in defense of a charge against them find a lot of political interference in their matters. Whether Nnamdi Kanu, whether Dasuki, whether Mustafa, whether there are legion of cases to establish that there are cases in which governments, whether APC, PDP, or what, a successive Nigerian government has shown to be partisan, to be interested, thereby rendering those cases and the judex almost impartial.
No, but that's the rubbish they talk about independence of the judiciary.
And I think that is why we're speaking out against it. And I can tell you that even some of the judges are not comfortable with that, because to a large extent it goes back to the quality and integrity of what we do as even practitioners in the temple of justice. For as long as we point out what we understand to be the challenges, now I've talked about institutional challenge, I've talked about infrastructural challenge, I have read out the constitutional and statutory provisions of the law that says, that supports my view that there are robust legislative mechanisms to ensure that we have speedy dispensation of justice. Yet, we still have delayed criminal justice system. So, the earlier we began to look in the direction of the solutions as we propose them, the better, not just for Nigeria, but for the image of Nigeria within the
community. My own question is this, because I have been around the judicial system.
That's right.
Yourself, so I understand a little bit of these things, because my own pain is that for the common man, as they say, the court is the lasso for the common man. For the common man doesn't want to hear any of this. What he wants is that, let me get my day in court and let there be equity, fairness, and good justice, and hopefully whatever happens becomes the case. Because if we begin to explain away the intricacies on why there is a miscarriage of justice or why there is delay in justice being served, it's almost like punishing the people for someone else's crime. Because the NJC should be able to do better, work against the clock, work against time to ensure that the common man feels comfortable in a Nigeria he lives in today, to say, at least if the government cannot do anything for me, at least the judicial system can protect me.
It is precisely why the discussions are on. It is just precisely why the legal profession under the auspices of the Nigerian Bar Association takes on these issues. It is precisely why even the National Judicial System, which is a self-regulatory body within the judiciary, have come under severe scrutiny by the public.
Rightfully so.
Yes, I agree. Some of us even have the courage to submit petitions. To say that, look, we cannot be part of this crisis. Rather, we seek to be part of the solutions. But here is the point. The argument that the justice you talk about, particularly justice, criminal justice, travels in 3 dimensions. Cannot be discountenanced, cannot be thrown overboard. It is justice for the state, which is a victim with respect to any crime committed. That is why in criminal trials, you won't see Aaron against Malachy.
Yes.
You will see Federal Republic of Nigeria.
Yes, the state against
Malachy. You will see Commissioner of Police against Malachy. That is to tell you that the state bears the first burden of that crisis situation. So justice to the state, justice to the victim of the transgression, criminal transgression that occur, and justice, even more importantly, to the accused person. So I bring an application to raise an objection regarding the nature of the charge that have been preferred against me. Oh, in the interest of speedy dispensation, no, you can't be this. You people have started again. By the time we take on this and you appeal against it, and then refuses it. If you refuse it, we're likely going to save at least 5 months of judicial time to be able to deal with that. But what it does is that you are arming me already with a serious ground of appeal on the issue of fair hearing, which is no longer a statutory matter, it is a constitutional matter. So that whatever decision you come out with, I'm going to hold on to that to insist that in the
as we wrap up, I'll ask you a yes or no question because
in the course of your trial,
yeah, no, because the reason why I'll ask you a question because they say that you lawyers are the ones that benefit from this protracted cases going on because you keep that means work is always on your table. But my question as we wrap it up, yes or no? Should we at this point in time declare a state of emergency on our entire judicial system?
The entire Nigerian system should end a state of emergency. ASU is threatening to go to strike. Medical doctors are no longer.
No, I'm not talking about that. I'm saying
that the entire Nigeria. So it's not an isolated case at all. And I need to be understood on that score.
Thank you very much for your time.
Thank you.